So, thank you, Mr. Chair. So I oppose this bill. You know, any of us who have ever presented a bill to a committee knows that once you present the bill belongs only to the committee. And if the committee passes it out, that bill belongs only to the House. And if the House passes it out, it becomes the Senate's. And if the Senate passes it out, it goes to the governor. And if he signs it, it becomes law, and it belongs to the people of Montana. And that's why Senate Bill 140, the bill that we're discussing here, like all laws, doesn't belong to its sponsor. It doesn't belong to its carrier. It doesn't belong to any committee. It doesn't belong to this House or the Senate, or even to the legislature as a whole, but to the people. And if one of those people believes that the law violates the Constitution, his or her constitutional rights, that person may challenge it in court, at which point our Constitution says that the law belongs to the court, and its defense belongs exclusively to the executive branch, specifically the Attorney General. And this is why neither the House nor the Senate is normally a party, let alone an indispensable party, as this resolution states, in any of the hundreds of court cases challenging the constitutionality of laws. If the House is now claiming to be an indispensable party to every lawsuit challenging a law, as this resolution claims, anyone challenging a law will be required to sue us, and we'd be required to hire lawyers to defend ourselves in hundreds of cases, multiplying this fiscal note by many magnitudes of order. To give you one example where this has played out, in a case called Newdow before the Ninth Circuit, the U.S. Senate sought to intervene in a case challenging the constitutionality of a law. The court rejected the Senate's motion and said, and I quote, "A public law after enactment is not the Senate's any more than it is the law of any other citizen or group of citizens of the United States. It is a law of the United States of America, and the government is already represented by the Attorney General." And the same is true in Montana courts. For example, in the case called Reichert v. State, citing that Ninth Circuit case and cases from all over the country, the Montana court said that the separation of powers in Montana's Constitution requires that, and I quote, "The defense of constitutional challenges is committed to the Attorney General, an agency of the executive branch. It is therefore inappropriate for members of the legislative branch to intrude in this process," close quote. So, even though the state is already well represented by our Attorney General, this bill wastes taxpayer money on a partisan cause while trampling all over the separation of powers in our Constitution. It invites us to be sued in every single case going forward where somebody challenges a statute as being unconstitutional. I know you guys have the majority. You can pass what you will. But as a good representative said not long ago, that doesn't mean you should. This bill should be an easy no. Thank you, Mr. Chair.